Welcome, everyone, to our second of three CLE series for the nonprofit section. We are going to have two presentations today. The first is an ethics presentation by D.A. Wilson, and then the second is a risk management consideration presented by Audrey Oliver. And in between the two sessions, we are going to have a very short, I promise it'll be short, annual meeting that will take about 10 minutes. But let's get to our first presentation. So D.A. Wilson is the founder and managing attorney of the Wilson Firm, a Metro Atlanta-based law firm. And he advises for-profit entities, nonprofit organizations, taxpayers, and athletes. He's also a member of the executive committee of the nonprofit section, and we appreciate his willingness to be here today.
All right, thank you for having me. It's an honor, and we certainly appreciate, your leadership with the organization, Catherine. And so I hope this conversation today is interactive as much as possible. We're going to be discussing ethics of pro bono and paid representation of nonprofit and tax-exempt organizations. So I know that's a bit wordy, but bear with me. Hopefully we can have a good time. Next slide. So just a rundown of today's topics and what we're going to discuss. First, various sources of ethical guidance for attorneys advising nonprofit and tax-exempt organizations. Second, we'll discuss legal differences between nonprofit and for-profit organizations. And then we'll discuss the role of an outside counsel for nonprofit and tax-exempt organizations. We'll take a brief pause for questions and comments, and then we'll get into some more information regarding specific questions and hypotheticals related to Rule 1.1, Rule 1.6, Rule 1.7, Rule 1.9, and Rule 1.13. And then we'll wrap up with some more questions and comments. And so what I will say is I'll be presenting today from my experiences, of course, from what I do with my firm, but I certainly encourage the involvement of other practitioners who may have other experiences. So the bulk of our clients at the Wilson Firm are typically smaller businesses, but some of you all may have experiences with, larger companies. And so I welcome the feedback and the questions and the comments. And so, have at it when we have a brief pause, but we'll jump into it. So next slide, please. All right, so various sources of ethical guidance for attorneys advising nonprofits and tax-exempt organizations. So it's important to note that there are no specific ethical rules governing the representation of nonprofit organizations. The rules and cases construing professional responsibility in the for-profit context offer significant guidance. This is important to know, right? So the same way from an ethical perspective that you would advise a for-profit corporation or a general partnership or an LLC, it applies to the nonprofit context, right? So there's very little or no difference. So you actually get a 2-for-1. So if you master it on the for-profit end, then you're good to go on the nonprofit side. Right, so sources, and this is just a reminder, you all are familiar with this, but there's the ABA rules of professional conduct, Georgia rules of professional conduct, ABA formal ethics opinions, state and local bar association ethics opinions, state bar ethics hotline, and then of course there's court decisions that flush out these ethical considerations. We'll discuss a few of these today. Next slide. So legal differences between a nonprofit and a for-profit organization, right? Which is very different from the ethical side, right? There are important legal differences between nonprofit and for-profit organizations that should be considered when advising nonprofits. Next slide. So, legal differences. First, nonprofits are mission-driven, right? It's the best way to describe this is nonprofits put purpose before profit, and for-profits put profit before purpose, typically. Now, there's some exceptions to that, but I think it's important to note, right? This is a philanthropic space mostly, and there are significant tax advantages for starting a nonprofit. And so the government wants to see that purpose really being at the forefront of the organization's activities. Now, it doesn't mean that nonprofits are not profitable. Nonprofits, in fact, are very profitable, or should aspire to be very profitable. Because if you're not profitable, then you can't run a business, right? Nobody wants to encourage an organization to run in the red, but it's how you put it, where you put your emphasis, right? And putting too much of an emphasis on the profit can be a bad thing. Second difference is the no owner rule, right? So there are no shareholders for nonprofit organizations. This comes up in practice a lot. I see this a lot with my clients. Someone will come in and say, hey, I own a nonprofit, right? And I have to correct them from the outset and say, you don't own it. Maybe you're a founder, right? Maybe you serve on the board. You also could be, an officer, right? But you have no ownership in this organization. Very, very important to know, right? Nonprofit founders, board members, officers can be removed from their organization for many reasons. So it's very, very important to have conversations. I always have with my clients to let them know you don't own this organization. You can be removed. You can't sell it. At the point where you want to step aside, you have to hand it off to someone else or maybe dissolve the entity. So very, very important, no owner rule, as opposed to shareholders that you have in for-profit sense. So another fine point to point out. The other one is for-profit boards are paid, nonprofit boards are unpaid. They're volunteer-based. Again, this goes back to the purpose being in the right space, and also too with the desire to eliminate an appearance of ownership, right? And so if you have a board, for example, that is being paid, then that can appear to be some type of ownership influence over the organization. And that's a no-no. It's a big no-no in the nonprofit tax exempt space. And so it is certainly discouraged to have a paid board in the nonprofit space. And of course, it is encouraged in the for-profit sector. Now, unfortunately, a lot of for-profit entities, maybe they don't have the resources to be able to pay their members as much as they like. But the short of it is it's forbidden in a nonprofit sense. So next slide, please. Legal differences continue. So nonprofit statutes allow for the formation of nonprofit corporation with or without members. Really, really important. When you're filing your articles of incorporation for a nonprofit, that's one of the questions that is asked. Will this entity have members or will it not have members? And it's a very important distinction. When you're filing for a for-profit corporation, this is not a question that is asked or comes up. For-profits don't have members. Non-membership nonprofits are managed by a board of directors in accordance with the board of directors' fiduciary duties. So again, if there are no members, if you make the election to create a nonprofit and there are no members, then it's largely governed by the board of directors. They have the most control and influence over the organization, of course, bylaws and the officers, etc. Members of membership nonprofits may have voting rights that empower them to make decisions on behalf of the corporation that are comparable to a board of directors. So the organizations, the nonprofits that elect to have members now have members that have a lot of influence and control over the organization. And there are many different types of tax exempt organizations. So some have members, some don't, whether it's a sorority, a fraternity, etc. And, because they pay particular dues, they have a lot of influence and a lot of say-so over the board and over the organization, essentially. Next slide, please. So the role of an outside counsel for a nonprofit and tax-exempt organization. Because nonprofits are supervised and overseen by the boards in most instances, it is important for attorneys to be sure that the board is informed and engaged, right? And I can't overemphasize that. Extremely important that the board is informed and engaged, and they're not fragmented from, the officers or, what's going on operationally with the organization. Next slide. Board members should be sensitive to remaining informed, engaged, and where necessary or appropriate, facilitate the role of outside counsel in dealing and communicating directly with board members. So I see this a lot. I try to be as involved as possible when representing a nonprofit, especially if they're at the formational stage. I like to have conversations with them early on so they're on the right track and kind of set the expectations of their involvement, right? You don't want to be absent, right? So some organizations do this by having outside counsel attend occasional board meetings and remind the board members of their legal obligations and responsibilities. And of course, they take questions and answers. So similar practice, right, for our firm as well, being involved as much as possible, whenever possible, because time is money. So they don't want you to be at every board meeting, but as many that you can be at is possible. It's good. One of the practices that I do here recently is I try to maybe offer, a training, like a 1-hour training to the board once a year, right? To be involved and say, hey, listen, let me be a part of this meeting, or let me conduct a training just to have a refresher of the obligations and the duties of your board. So I found that to be a really good practice, a really good measure to stay involved as much as possible. Next slide. So we've kind of pushed through that quickly, but I wanted to open the floor up for some questions or comments based on anything that we discussed thus far before we get into some of the, the heavy substantive information, especially pertaining to the rules of ethics. So anyone have any questions? Are there any questions, comments in the chat? Nope. All right. No news is good news, I suppose. So next slide, Catherine. So rule 1.1, competence, right? And what we'll do here is we'll go over some different questions, some different hypotheticals. Feel free to chime in if you have questions. Again, you have some experiences, certainly open to suggestions and your thoughts. So question 1, is it ethical for an attorney to advise a nonprofit on a type of issue he or she does not regularly handle? When should an attorney engage other lawyers with specific expertise? Next slide, please. So Rule 1.1 states a lawyer shall provide competent representation to a client. Competent representation as used in this rule means that the lawyer shall not handle a matter which the lawyer knows or should know to be beyond the lawyer's level of competence without associating another lawyer with the original lawyer who the original lawyer reasonably believes to be competent to handle the matter in question. Competence requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And so this, this is where, the analysis begins, whether or not you should take on a client or not, or whether or not you should even advertise to certain clients, but you have to be competent. And one of the areas that I've seen this come up in practice pretty regularly, and we kind of touched on it earlier, but not in great detail. We discussed the difference between a nonprofit and a for-profit entity. But one of the things that we didn't discuss was the difference between a nonprofit entity and a in tax exempt status, right? And so I've seen this in practice come up a lot of times. There are attorneys that are very familiar with the Georgia Code, nonprofit code, but they may not be as familiar with the tax exempt laws, right? So as you all may know, there's a bunch of different 501Cs, right? So there's, I think, 29, maybe 30 different 501C categories. And it's very difficult to have command over all 29. In fact, I haven't met anyone that is extremely competent in all 29 areas. And so what I see a lot in practice is, a lot of attorneys that just default, every nonprofit to a 501c3, right? 501 used to be a 501c3. And then, subsequently, our firm may represent them for whatever purpose, and we determine that maybe they should not have been a 501c3. Maybe they should have been a C6, C4, C7, whatever the case may be. And so, this question kind of raises an issue of, when does an attorney become competent to advise this organization on both sides, right? Because you gotta have both sides. I was fortunate in my tax program to take a few tax exempt organization courses, and so I really studied it from a classroom perspective on the federal side. And when I got into practice, my nonprofit Georgia code was not as strong, and so I had to spend a lot of time in CLEs shoring up that side of this representation. And so, I would challenge attorneys to, before they jump into this space, until they decide to represent these type of clients, to make sure that you're well versed on both sides of it, because it can be very challenging. Like I said, with 29, 30 different 501c classifications, making sure that you've chosen the right one, understanding the various rules for the organizations that may have members versus the organizations that do not have members. It's very, very important. And so, comes up a lot. This is an example that I see, but, the short of it is, in order to be competent, it's not about experience necessarily, right? You can have an attorney that, maybe has only been practicing for a couple of years, do a better job than someone who's been practicing 30 years. Maybe the attorney that's been practicing 30 years is just lazy, right? Or maybe their practice has been just kind of confined to a very limited area, whereas the individual who's been practicing for 2 or 3 years has taken on more complex matters across the board. And so I try to encourage attorneys to make sure that you're not just looking at, the years of service, right? Being sure that you associate yourself with other competent attorneys. I've had to do this, several times, whether it's a tax matter that's criminal in nature, and I'm not a criminal defense attorney, bringing on a co-counsel or associating myself with a criminal defense attorney that I feel can help me out in this space. Or, there have been times where I've had to associate myself with a CPA, even though I'm a tax attorney, just to answer questions. And so not being above, asking for help is something that I always encourage in this space, and it really protects you from those, competence, arguments. And the other thing, one of the things I did early on in my practice is I did a lot of CLEs. I started my practice right out of school, and I didn't have a bunch of mentorship. And so what I did was I used CLEs as my mentors, and I did, for years, I was always way over my CLE, hours, just because I wanted to shore up some of the shortcomings, and I wanted to be as competent as possible. So those are the few things that I did, associating myself, taking CLEs, being thorough, having additional, LLM and tax certainly helped me out as well. And I still try to practice those things going forward. So that's what I'll say about competence. There's a bunch of different factors that you can consider, but I don't want to just read the code to you all. You can do your own reading in that regard. So we'll move on to the next slide, please. Rule 1.6, confidentiality of information. Excuse me. How do confidentiality rules apply when working and sharing confidential information with the client's non-lawyer advisors, such as accountants, fundraising consultants, etc.? Next slide, please. Rule 1.6a states a lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate, or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or are required by these rules or laws or by order of the court. So in short, it's important to understand that you have a duty of confidentiality, right? And one of the things that we can do when we're representing nonprofits is to have conversations with our clients about the nature of information being sensitive, right? Communicating to them, hey, this is sensitive information. Please do not disclose it outside of the organization, right? Because if you do disclose it outside of the organization, then you could be waiving your attorney-client privilege, right? So very, very important. You don't want to give up your attorney-client privilege simply because you've been talking to people outside of the organization. Fortunately, this comes up in my experience a little bit more often in the nonprofit space than in the for-profit space. And so this is a conversation that needs to be discussed in terms and also having policies and procedures internally to prevent information from being leaked. One of the best methods that I've come across is when I do have to disclose or hand out certain sensitive information. What I try to do if I'm meeting with the board, instead of shooting out an email, which emails go everywhere these days, they can end up on social media, etc. Maybe there's information that I only decide to disclose in writing, right? And so I have a board meeting, handing out information that is confidential in paper form, or maybe just talking about it. And then after the meeting, taking that information up, right? Because once you put in an email, it can go any direction, as I said before. So there may be some things that you decide to call a meeting and communicate face-to-face or hand out documents, as I said before, and take them up. But the goal is to make sure that your board is informed, along with your officers as well, and they're not leaking confidential information and destroying the relationship that you have with them. All right, next slide, please. Also, you can stay right there, Catherine, but I did want to add one other point. As it pertains to communicating with maybe an accountant or something like that, right? There's also the Covell agreement that you can establish with the CPA. Now, you have to be very careful with that, because the short of it is CPAs do not have the same attorney-client or client confidentiality relationship. Their information can be accessed via court order or the IRS. And so having a relationship with them, making them subordinate to you for the purpose of litigation, they now have your privilege and they're protected. I've actually had that scenario happen a couple times when it pertained to an IRS case, and they were trying to gather information on my client through the CPA that I had retained, and it couldn't. So, that's another opportunity for you to be able to create that protection, the extra level of protection for your client through a Covell agreement or a Covell letter. So. Okay, so rule 1.7. And here's a question. So conflict of interest. What issues arise when representing related entities, affiliates? What is the best practice for getting conflict waivers and handling confidential information received for one entity or another? Next slide, please. So, Rule 1.7a states a lawyer shall not represent or continue to represent a client if there is a significant risk that the lawyer's own interest or the lawyer's duties to another client, a former client, or a third person will materially or adversely affect the representation of the client, except as permitted in B, which states if client informed consent is permissible, a lawyer may represent a client, notwithstanding the significant risks of material and adverse effects, if each affected client or former client gives informed consent, confirmed in writing to the representation after consultation, having been received in writing, and having been given an opportunity to consult an independent counsel, right? So this is the general rule for conflicts of interest. Comes up all the time, and I'll ask you to go to the next slide, please. Certainly comes up all the time, but this is really speaking towards, working with an organization that could have, subsidiaries or affiliates, et cetera. So, for example, in the nonprofit space, I attend a church, I won't say their name, they're not a client, but, they have multiple entities, school, another facility, just a bunch of different things. And so, what happens if, the church becomes a client of the law firm? Do I have a conflict of interest to those affiliates, to those subsidiaries, et cetera? It's a good question, right? So, excuse me, it's important for an attorney to be careful in assessing whether it is appropriate to simultaneously represent related entities, whether or not a conflict waiver is secured or is deemed necessary. Or firm represents both sides of the transaction unless the interests of the entities are clearly aligned in all respects. And so you'll hear that a lot, right? The clear alignment. That's the big issue here. On its face, it looks like a conflict of interest, but there's a little bit more to be analyzed, right? It is often a good idea to have a second attorney come in from one of the entities and look at the transaction, even on a limited basis, to ensure that the interests on the second entity are being provided. So it's nothing wrong, and it's a best practice to bring in another attorney so he or she can assess the issue independently. Not only should the attorney secure written conflict waivers from both entities, but he or she should remind both parties of the situation. So putting things in writing, creating a paper trail is very important. Next slide. So, and I'll try to paraphrase this a little bit, but the short of it is, and there's been case law to kind of go over this and kind of flush this out, right? On its face, there isn't a per se rule that states that there's a conflict of interest, right? What should happen, what you should do is make sure that, again, you're communicating with both parties that there's a conflict of interest or potential conflict of interest, that you also put those things in writing, right? Sometimes you will enter into an agreement that states, you know, you do have you do have an obligation to all our subsidiaries, affiliates, et cetera, right? So that's an exception. That also comes up contractually where that language is included. And so you need to be on the lookout for that, whether or not that's been agreed to in writing. But if it has not been agreed to in writing, then there's not just a per se rule that states that you have a duty or an obligation to a subsidiary or an affiliate. So it's very, very important. Now, does it look good? Probably not, right? And so although, you know, you have no specific obligation, what I would encourage you all to do is to get everything in writing in these instances. And, you know, try to avoid these appearances as much as possible. Next slide, please. Right. So it's a little bit different. This is rule 1.9. And this pertains to, you know, a former client, right? And we'll address this by, you know, coming up with a hypothetical. And, you know, if there are questions, hopefully someone wants to raise their hand and maybe give us some feedback on it, you know, we can go from there. But the question goes, company hired attorney to represent it in a tax dispute with the IRS. The IRS accused the company of failing to report unrelated business taxable income. While attorney was representing company in dispute, attorney learned extensive private and confidential financial information about the company. Attorney's representation of the company ended 1 year later after a tax dispute had been resolved. Several years after the attorney's representation of the company had that representation of the company ended, the former employee of the company filed discrimination claims against the company. Attorney was the only lawyer employee knew, and she retained attorney to represent her in a discrimination case against the company. Company's lawyer moved to have attorney disqualified for representing employee. Attorney claims that the matter was not substantially related enough to merit disqualification. So the question is the attorney correct? Is the attorney disqualified, or should they be disqualified because they represented the company for an unrelated business taxable income matter, and now someone related to the company is now trying to retain them for a discrimination case? Next slide, please. So rule 1.9a, a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or as substantially related matter in which the person's interests are materially adverse to the interest of the former client, unless the former client gives informed consent confirmed in writing. B states a lawyer shall not knowingly represent a person in the same or substantially related matter in which the firm or which the lawyer formerly associated had previously represented a client. And without reading it word for word, the most important thing to highlight here is substantially related, right? What is considered substantially related? Very, very important, right? And so I'll read a definition. Matters are substantially related for purposes of this rule if they involve the same transaction or legal dispute, or there otherwise is a substantial risk that confidential factual information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter, right? And so that is substantially related and really, really important. So, and maybe we'll take some questions here. But for this particular hypothetical, we should consider, one, how similar are the claims at issue in the current case and in the prior case? So it's a good question, right? And you may be familiar with an unrelated business taxable income versus discrimination. I'm more familiar with the unrelated business taxable income than I am discrimination. But what I know about unrelated business taxable income is that this issue really is designed to determine if a particular nonprofit is taking in a form of income that's not really associated with this purpose, right? With this tax exempt purpose, status, etc. And if it's not, then it has to be held out and treated differently, possibly taxed. And so, you'll see this, maybe you have a church or something and, they sell CDs. I mean, I know nobody sells CDs anymore, but this is the best example I could think of. They sell the sermons on the CD, but they also rent out space on the weekend in their parking lot to their neighbor who, is a hospital, whatever the case may be. And so you're looking at that income and you're saying, the sale, the rent of, parking lot Monday through Friday has really nothing to do with someone's faith necessarily. And so the IRS may say that's not related to your purpose, and so maybe you need to be taxed. Unrelated business, the CDs are connected to your ministry, you're spreading the gospel, whatever the case may be. And so they may have two sources of income, right? What does that have to do with a discrimination case, down the line, 7 years later? Well, I mean, there's an argument that probably has nothing to do with it, right? And so, is there a conflict, just based on that one question? I'm sure, all attorneys here, or I think we may have a few law students, but, there are arguments to be made on both sides, but that's a question that you have to consider, right? How similar are the claims at issue the case into the prior case? And there's an argument that they're not very similar, right? The next question you can ask is, to what extent do the factual and legal issues overlap, right? Which is very similar to the first question, but this would be something that you would need to analyze. So if I were advising an attorney about this particular matter, what I would say is, hey, before you take that case, maybe you need to review your file, prior to, and see if there's anything in there, that could have been problematic or maybe related to the discrimination case, right? It doesn't sound like it, but certainly there could be something that was said or done when you were working the other tax case that may have some overlap here. And so, that's a really good, really good practice, right? Before you move forward, check that out. So the next question I would ask is, what confidential information was acquired from the client in the course of the lawyer's prior representation, right? So again, this would probably be a review of, your file to figure out what was confidential, right? And I don't want to create a crazy, hypothetical, but maybe there was something, when you were reviewing these sources of income, that, maybe someone was terminated, wrongfully, when you were selling the CDs or when you're renting out your parking space. There could be something there, who knows, right? And then, the final question would be, would any of the confidential information be relevant to the current case? Again, it has the same flavor as before. What can you possibly tie in from the former case that may affect the new case? And this is going to be something that's going to be, you're going to have to be very diligent about, to make sure that, there's nothing there that could possibly come up. Ultimately, this is a tough question, and when I would just say, if I had to talk to an attorney, like, just don't do the representation, right? Because it just doesn't look right to represent them in one space and then, be opposed to them down the line. But then I start to think about, the fact that I'm in the Atlanta metro area, in that, you know, part of my practice is I don't necessarily mind making that decision because there are always a lot of other clients, right? But maybe you think about, some of the attorneys that are in very rural areas, where there's like one gas station, there's one grocery store, one movie theater, etc. And how difficult it may be for them to get more clients. And so they may be in a position where they represent everyone in the entire city, and this could come up a lot in their practice, a lot more in their practice than in my practice. And, again, there could be someone who's been practicing for 30, 40 years. And at this point, the conflicts just come up more frequently. And so, it's important, it's important to know that this is just not a clear-cut answer. It certainly doesn't look right. Certainly doesn't look right. But is it a hard yes or a hard no? It really depends. It really does depend. A couple of examples where I would say maybe it would be a hard no is, let's say that I decide to represent, a successful businesswoman. And this successful businesswoman, as a part of that representation, I learned very detailed information about her finances and her business, etc. And then, afterwards, years later, her spouse comes to me and wants to file for divorce. Well, it's obvious. I've gathered so much information. These financial matters, these business affairs are going to be significant. They're going to be significant issues for the divorce. And so in that situation, I would say that would be too substantially related to push forward. And so that's an example where I could certainly, see where you don't need to move forward. It's a bit more obvious, a little bit more obvious than our example. But it could go either way. Certainly could go either way. And again, the 4 questions that I wrote out, you all will have access to these slides. I think they're good questions to ask. And and you want to be as detailed and as prudent as possible. So move on to the next slide, please. Okay, next slide. Rule 1.13, organization as a client. Excuse me, what should a lawyer do if he or she learns that an act has been or is about to be committed that violates a duty to the organization or that violates a law in a way that might be imputed to the organization? Would your answer change that the violation is likely to cause substantial injury to the organization? Next slide. So 1.13 states a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. So this comes up, all the time. Again, my practice is probably at this point 80 to 90% business stuff, for profits and nonprofits, and so this is a part of the conversation with clients all the time, right? Who hired me, right? Who is the client? Well, the engagement letter states that the business is the client. It's not the individual. you work as an agent on behalf, but I have an ethical obligation to the organization, right? I have a duty to serve its interests and make sure that it's protected pretty much at all costs. And so, going back to what I stated before, especially in the nonprofit sense, people come and go, right? You could be the founder of the organization, but you're not the owner. And oftentimes, well, I won't say often, but there's some extreme examples where the founder had to go or had to be disassociated, or someone related to the organization had to be removed because of things that they did. And so, most notably, Lance Armstrong removed from his nonprofit. Kanye West was unassociated with his mother's nonprofit, et cetera. Just some extreme examples. But, as the attorneys for these organizations, I'm pretty sure, we're advising these organizations on whether or not they have the duty or the ability to be able to make these very tough decisions. And so the rules are very clear. We absolutely do. So next slide, please. So 1.13b states, if a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in action, intends to act, or refuses to act in a manner related to the representation that is the violation of law, obligation to the organization, or a violation of law that reasonably might be imputed to the organization and is likely to result in a substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization, right? Very, very, very straightforward there. Our job, and again, this applies to for-profits and nonprofits, is to act in the best interest of the organization. And it's challenging because, when you're representing a business, what I've found is, especially as a tax attorney, you're dealing with a lot of things that are financial, and financial matters can get very personal, right? It's not as cut and dry when you're dealing with money, or you may be dealing with taxes and things of that nature. And so you begin to build relationships with, with the individuals of the organization. And oftentimes, that can go left, unfortunately. And so, what do you do? So a couple things, right? You need to consider the seriousness of the violation, right? It's really, really important. Again, it's not a hard, fast rule, but you need to think about, okay, is this really serious? And if it is, I have a responsibility. I really do. I just can't, sit on my hands. Let me see here. So it may be appropriate for the lawyer to ask the constituent to reconsider the matter, right? So there are instances where maybe the individual that you have a question about is just misinterpreting the law or doesn't understand something. And so you can have a conversation with them. You can, from a judgment perspective, you can say, well, they're considering doing A, B, and C. And it sounds like the reason why they're considering that is maybe because they're not malicious, but they're just misinformed. And so I'm going to have a conversation with them about A, B, and C and try to educate them and inform them from a legal perspective, what is right and wrong in this scenario. And if they in turn listen to you, right, they have an opportunity to listen to you and, do an about face, so to speak, then you could have a successful outcome, right? But if they decide not to listen to you, after you have, kind of tried to read between the lines and see whether or not they're just misinformed or misguided, and taking the time to advise them, then it's pretty straightforward. You have to act in the best interest of the organization. And again, this could be reporting this individual, reporting these actions to the highest authority, that could help you in this situation. And so, again, it's not easy. It can be very challenging at times, but it's certainly something that you should, consider, whether or not this is serious enough to report immediately, or whether there's a little bit of discretion and you can inform your client and maybe have a conversation with him or her and maybe talk them off the ledge, so to speak. So it's important to note that, whatever direction you go in, it needs to be done timely, right? What you don't want to do is be thinking over this hypothetical for a few weeks. Well, maybe I don't know if they're serious or not. I'll just let me sleep on it. I'm going on vacation. I'll get back to them, because that's something ultimately as an attorney, you could be held responsible for. And so your decision-making process needs to be very timely, needs to be swift, needs to be decisive, especially if it's something that you consider to be, very serious. So if it's serious, and you decide that they may be a little bit off, jump in there, have a conversation with them, and then move accordingly. Or if it's serious enough, just escalate the situation as fast as possible, because at the end of the day, going back to the last sentence, whatever is in the best interest of the organization. So let's see. Next slide. And that's it. That's all I have for you. Hopefully it wasn't that painful. I wanted to leave maybe 4 or 5 minutes for some questions or individuals that may have some pointers for the group, may have been practicing this space for a long time or even a shorter period of time, and they may have something that they can offer to the group.
Ladies and gentlemen, at this time, if you would like to ask a question, please use the Q&A feature or the chat feature.
Oh, I do see it's Kovel, Kovel. I'll put that in the chat. Someone asked, can I spell the type of agreement? That you can use to create the relationship between the CPA. I don't know why. Well, I do know why it didn't get the automatic. Kovel, and that comes from a pretty landmark case in the tax industry. And even though that was a direct message, I thought it was a good question to share with the group. You can, so short of it is, and I'll go over this a little bit more. As a tax attorney, there are a lot of things in the tax space that I have to rely on from CPAs. I don't think just because I'm a tax attorney that I know everything. There are a lot of great CPAs that teach me a lot. And I want to be able to communicate with them pertaining to a particular matter without the IRS, grabbing their information, because they don't have the same relationship that we have with our clients. And so I can enter into that agreement with them to protect them and their information about my client. And again, I've had to do that before, and even had I would say a mild dust up with the IRS pertaining to that, but they didn't push us. We were successful with protecting that relationship. And so it's a very valuable agreement, especially in the tax space. You're working with a lot of CPAs. So hopefully that answers the question. But other than that, I mean, that's all I got. I don't have any other questions out there.
There's one more, DA.
Okay.
From Joel Arrighetti. What are some common issues you see when advising not-for-profit board members? What are practices to avoid other than paying board members?
Other than paying board members, I got to be careful the way I answer this question in front of other lawyers. Um, you know, I would say this, right? There are opportunities for you to not physically compensate or pay cash to your board members, but maybe once a year or twice a year, you have a retreat, right? And Joel, you've got far more experience than I do, so if you want to chime in, let me know. But you know, sometimes what you can do is, you know, do a trip or something, a training opportunity for your board members, and you know, something to kind of help them in that regard. But certainly you don't want to pay them cash. You know, there are some opportunities. You know, if you have a board member that is sophisticated enough to maybe retain them in an outside capacity as a special advisor, some type of committee. But you got to be real careful with that, right? Because that appears, you know, it appears as a conflict of interest as well. But those are two kind of areas that I think you could do to not necessarily try to compensate them in their board capacity, but bring some value to the table, because they do spend a lot of their time with these organizations. And some of these boards are very large. So, you know, again, a lot of my clients are smaller, so my clients are happy not to pay their board, or even appear to pay their board or offer anything that's incentivized. But Joel, if you want to jump in, if you got some best practices, I'd be happy to hear from you.
The only thing that I would say is in that area is having a written conflict of interest policy and having all board members sign an acknowledgement and receipt, and make sure that all new board members go through some type of orientation, because as boards get larger, oftentimes stakeholders will be board members. Occasionally, they may provide services, supplies, paper goods, you know, catering services and things like that. You just have to be very mindful of that. Make sure that they're done at arm's length. It's the old adage, no good deed goes unpunished when you deal with board members who have a financial interest in the organization.
No, and that's, yeah, no, that's a great point. I appreciate you sharing that with the group. I had a similar issue a couple months ago, where there was a board member, and you know, the company needed a golf cart for just back and forth activities, and you know, they were concerned. They were concerned because of the conflict of interest. And so we did exactly what you said. You know, we revised, you know, the conflict of interest policy, made sure that it was solid. We had a conversation with the board, you know, because again, especially with the smaller organizations, a lot of times the board is the primary source of resources. And, you know, you have to find a way to kind of navigate those things. Again, arm's length transaction, you know, it's the same language that we gave to them. Whatever you would sell or lease this to a stranger on the street, you know, it's got to stand up the exact same way. So certainly appreciate that. Very good point, Joe. And I think we're right at 1 o'clock, and I know we've got to do the annual meeting. So any other questions?
Thank you, TA. We appreciate you presenting on this, and I know everyone is glad to both learn about this and also get an ethics credit, which everyone always needs right before the end of March. So thank you again for taking the time to do this.
Oh, thank you for having me.
So next on the agenda is our annual meeting. And as promised, we will keep this short. So let me pull up that presentation. And okay. Thank you for making that easy. So for our next speaker, Claire Oates is going to introduce Audrey.
Yeah, hey, good afternoon, everybody. Now that we are through that very stressful vote, it is my pleasure to introduce to you Audrey Oliver, who is going to present the next session on risk management and youth serving organizations. Audrey is a licensed attorney in Texas and the director of consulting at Presidium, which is a national leader in abuse risk management. In her decade in the youth safety industry, Audrey has partnered with various Olympic sports, the YUSA, and Boys and Girls Clubs to help create and maintain safe environments for young people across the country. I personally have worked with Audrey for many, many years and always benefit from her expertise and her perspective. So I'm glad she is here to share that with all of you as well. So thank you, Audrey, for being here, and I will hand it over to you.
Okay, thank you so much, Claire. I am so excited and honored to get to be with all of you today. Just really excited for the opportunity to share a little bit about Presidium and how we help organizations who serve youth or vulnerable adults, help them manage the risk of child sexual abuse. So real quick, I'm going to just make sure that my screen is sharing appropriately. Okay, so, and if at any point you have questions or anything that you want to get clarification on, of course you can, I'll pop up my contact information at the end and please feel free to reach out, but you can also put questions in the chat and I will try to address those. So just a really quick, and thank you, Claire, for the introduction. Just a quick kind of background about Presidium and who we are. We are an abuse risk management company. We are based in the Dallas-Fort Worth area in Texas. And we just last year celebrated our 30th anniversary. And what we do is we work with a variety of different youth serving organizations, as well as organizations that serve vulnerable adults, to really help them understand the risk of sexual abuse within their programs. And so we are very narrowly focused on that area of expertise. And so we have a whole team of consultants from a wide variety of backgrounds. We have several attorneys on our team. Myself, I am an attorney in Texas. And we have social workers, psychologists, we have people with law enforcement background. We actually have one who has a master's in cultural anthropology. And so we have this very intentional multidisciplinary team to really make sure that we are covering all aspects of this risk. And so our team of consultants, we work with thousands of different clients, and also what we do is we analyze cases of abuse. And so we look at when we have an incident within a youth serving organization, we look at it and we do a root cause analysis to see what are the factors that led to this, what contributed to this, where was the gap, where was the potential breakdown in operations that led to this specific incident happening. And so we have analyzed thousands of cases to this date, and we know that when abuse happens within an organization, it's not because of 800 different reasons that were that root cause, but because of a breakdown in one or more of 8 different operations of an organization. And so I should have included the slide here, but I'll show you the safety equation slide, which is those 8 operations. And so that is the basis of our work at Presidium. And so we help organizations really understand what is it within each of those 8 different operations that you need to be doing to most effectively manage this risk. And so we have been working with Boys and Girls Clubs of America for many, many years. And I am just so appreciative of Claire for inviting me to talk to you all today and really share kind of how we help our clients, but also just more about the risk in general, and also some information about some loss data that we have been working on at Presidium, just to give you a picture of what is the impact of sexual abuse within an organization, and how can we really help organizations understand, okay, here's the impact, but what can we do? Because there are tangible things that we can do to prevent a risk or an incident of sexual abuse. So with that, I know many of you probably, hopefully, don't think about sexual abuse on a regular basis. So just want to kind of frame, what is this? Is this really that big of a risk? Is this something that is happening all the time? And unfortunately, it is. And so we know that 1 in 4 girls and 1 in 13 boys will be sexually abused by the time they turn 18 years old. So that's a pretty staggering statistic from the CDC. And so we know that this is very prevalent. This is something that I know Claire can attest to. This is something that large youth serving organizations is one of the top threats to their movement and their mission that they're trying to accomplish, is making sure that we create a safe environment, particularly an environment where we are not, or rather where we are limiting the possibility for an abuse incident to happen. And so to tie on to that, we know that youth-to-youth sexual misconduct occurs at a higher rate than adult-to-youth. And so we know that, and I won't go into too much detail about this today, but we know that there are multiple different types of abuse, but we traditionally have seen organizations focus pretty heavily on really preventing, responding to, understanding adult to youth sexual abuse. And so what we've seen in the last 5-6 years is really a shift to try to educate and understand that the impact on, of course, the survivors that are involved, but the impact also on an organization itself, if there's a youth-to-youth incident, is and can be just as horrific and impactful monetarily, reputationally, as an adult-to-youth incident. And so we work with organizations to really help them manage not only the adult-to-youth risk, but also really looking at things like supervision procedures to really help with that youth-to-youth risk as well. We know that 90% of the time, a victim, survivor knows their perpetrator. And so we know that if it's not a familial abuse case, most of the time it's someone that is in that child or adolescent's life. And so it's someone who, maybe it's at their school, at their after school care program, at their sporting league, at their insert whatever program or activity that a child might participate in. And so it's, we know a lot about how offenders who want to engage in inappropriate relationships with youth, how they engage in those grooming habits and grooming behaviors. There's been a lot of research that's come out recently about the different ways that these offenders will ingratiate themselves towards not only their victims, but also their victims' families or their victims' communities, to really make sure that they're able to essentially fly under the radar without being caught. And so it's very rare that we have kind of the stranger danger case of sexual abuse, but we know that still happens, but the high prevalence of it being someone that the child knows, particularly within some sort of youth serving organization that the child participates in is one of the reasons why this is such an important risk to manage. And then we know that 80% of abuse does not get reported. And so there are a number of different reporting barriers to victims and survivors coming forward. And so we know that a lot of times children and adolescents feel very shameful about the behavior. They may feel like they don't know who they can report to, who they can trust. And they're also, they may not know that it's actually a behavior that is wrong and something that they need to report. And so this is why we work a lot with organizations to help them understand that not only do we need to train our staff to understand how and when to report if they see something or if they receive a disclosure, but it's also important to as an organization that serves youth, that we need to provide some level of information to the consumers that we serve to really let them know, here's what conduct and behavior is acceptable in our organization. And if something happens that goes outside of this, you can tell someone, and here's who you can tell. And so we've seen like Boys and Girls Clubs of America, YUSA, do a great job of equipping their local associations with information and ways that they can encourage that reporting, because we want to create an environment where we can hear those red flag behaviors, those policy violations before they escalate to an actual incident of abuse. Okay, so I just covered that. So like I said, when we are working with organizations, we want to help them understand that we're not just managing the risk of an offender, an adult coming in and abusing a child, but we're also looking at youth to youth, sexual activity, sexual misconduct. And so we know that it takes a bit of a different understanding of how to create policies and procedures and really create just organizational infrastructure as far as like supervision and monitoring high-risk activities. That is a little bit different when we look at youth to youth abuse prevention versus adult to youth. And so when we're looking at managing the risk of adult to youth, there's a high emphasis on not only creating strong policies that really identify and define the acceptable behavior within an organization, but that also we are looking at our screening measures. So how are we vetting and selecting the people that work in our organization or volunteer in our organization? So things like background checks and interviews and reference checks. And so how are we controlling access to our consumers and as well as training? And so it's very important that we work with organizations to help them develop a really good training plan for all of the staff, high access volunteers that they have, to really help them understand not only organizational expectations, but also red flag behaviors for potential abuse incidents that might happen. And so it's a little bit different than youth to youth abuse risk management, where we really want to, as an organization, we want to focus in on what are our supervision procedures? How do we, when we have staff who are supervising our youth, what are they doing? How are they doing that? How are we limiting opportunities for one-on-one interactions? How are we limiting opportunities for youth to have private interactions with each other? And so it's a little bit of a different approach. And so we help organizations understand the education piece behind that, but also the need to implement different types of policies and procedures to manage those types of risks. So I wanted to share, we recently completed at Presidium a large loss analysis where we were able to look at a collection of insurance losses that were paid out. And so we looked at cases from 2000 to 2022. And we looked into, because we wanted to see, a lot of times with organizations, you know, there may be a disconnect on the, sadly, there may be a disconnect on the kind of emotional and moral side of things where, you know, you want to do the right thing because you are an organization that serves youth and safety is very important. But a lot of times, if there are leadership in an organization that are a bit disconnected in that way, the monetary impact and consequences can sometimes resonate a little bit better. And so we wanted to see, you know, when we have an incident, when we have a sexual abuse claim that comes forward, what are the average payouts? What are the losses, the financial losses that these organizations are seeing? And so as you can see with the data, it has steadily gone up. And the impact of that is, of course, we see that a lot in the insurance world. And so when an organization that, you know, say, for example, we have a mentoring organization who provides one-on-one mentoring, maybe it's educational help. When they're going to apply for insurance, it's going to be very difficult to obtain that insurance because of the just very, very large payouts that these insurance carriers are having to do because of sometimes just one incident of abuse. And so it's quite staggering to see when you have one incident, maybe you have one victim, one individual, and you see you know, multi-million-dollar settlements coming out of that. I mean, that can end an organization. We've seen these bankrupt organizations, both on a very large scale, like Boy Scouts of America, or on a very small scale, if you have a small local organization that just can't overcome an incident. And so this is where sometimes this is what connects with people to help them understand, like, this is not just a risk reputationally and you know, something that we owe a duty to the people that we serve to create a safe environment, but we have a significant financial risk here as an organization. And you know, if organizations are not able to obtain insurance, that could mean that they're not able to continue with operations. So what we're seeing is that this is just a breakdown in the industries that are represented in that analysis. What we're seeing is that when we look at those cases, we see these different areas of fault. And so this is right in line with the risk management on the prevention side of things, where we want to put into practice procedures and policies that really help our staff understand the core purpose and how to supervise our youth that we're serving, but also how to supervise each other so that we're creating that safe environment, so that we're actually following through with whatever our supervision expectations are. And so, for example, we often see when we Presidium are doing site visits with an organization, we will often see that you know, maybe it's during gym time and all the kids are playing dodgeball or something in the gym, and they're playing and they're engaged in the activity. Well, that's often a time when we see staff who think, okay, I can take a step back and relax for a second, and maybe they go and they talk with another staff member or they check their cell phone. And, during that time when they're not actively supervising or actively engaged, it's very easy for a peer-to-peer incident to happen, or for another adult to come into that area and potentially interact inappropriately with the youth. And so we have to, that's just a very small example of how we have to, as an organization, establish what are our policies, what are our expectations, train to those, and then also make sure that we are following through with actually implementing our supervision expectations. And so we also see negligent response. So how an organization responds to an incident can be very, very damaging, but also, there's a lot of ways that organizations can very positively respond to an incident, because we can't, at the end of the day, we can't 100% guarantee that any organization is not going to have an incident, but if they can respond really well to them, it can limit the amount of loss that they feel, and of course any reputational damage and damage to the survivors that are involved there. So we want to make sure that organizations have really good crisis management response plans, that they know how to have a survivor-centered, survivor-focused response plan. And so that can really be a big difference between, how an organization is viewed, not only if, for example, if media gets involved reputationally, but also how that, case or claim gets settled. And then, of course, hiring. We see that organizations sometimes will skimp on their hiring procedures because of a variety of factors, whether it's timing, they're in a time crunch, or there's a nationwide shortage right now of staff who are interested in working at some of these youth serving organizations. And so not only is it they're competing with any other place of business that is offering more money and less hiring barriers, such as interviews and reference checks. But we have to really make sure that organizations understand that we can't sacrifice background checks, interviews, applications, reference checks, because that is our only, I don't want to say only, but that is the area where we have the most control as an organization over who has access to our youth that we serve. And so if we're not doing a good job, if we're being negligent in our hiring practices, that's a huge gap and a huge area of vulnerability. And so we often encourage organizations to really invest the time and the resources in developing a very strong, very consistent screening process, so that you can really take the time and make sure that we're actually having good controls over who is let into our organization. Okay, so this is the safety equation that I mentioned earlier. So these are the 8 different operations, and this is what is the foundation for all of our work at Presidium. So we have within each of these 8 different operations standards that any organization, and these standards are backed by research and of course our root cause analyses. And each of these operations has standards that an organization should be meeting to create a safe environment from an abuse prevention standpoint. So those standards are publicly available on our website. So if you're interested in some light reading, you could go and download those. But that is what guides all of our work. That is what helps us when we are working with clients to really understand where are your gaps. Where do you need help with policies? Are you not screening appropriately? Is there room for improvement with how you respond to incidents or red flag behaviors that happen? And so it really helps to kind of streamline and understand and kind of untangle this web of overwhelm that a lot of organizations feel of, well, there's just so much that we have to do. There's so much we have to comply with. And this it feels impossible. It feels impossible to know that we're never going to be able to 100% prevent something like this from happening. But there are a lot of really good and easy things that organizations can do. And so those are, again, rooted in our standards. So feel free to go download those if you're interested. And so we know that we can't guarantee an incident's not going to happen, but abuse is preventable. And so if we are using these operations, using the practices that we have within these, and they're working all together to create this safe environment, we can prevent abuse. We can prevent that from happening, and we can create a culture of safety within an organization. So we have our standards, they're clear, we enforce them. Everyone across our organization knows what their job is in relation to safety. And so that's everyone from the CEO, board chair, all the way to our frontline staff, our operations and maintenance staff. Everyone should know what their role is with regard to abuse prevention and safety. Everyone takes warning signs seriously, so we do a lot of education on, we want to prevent abuse before it happens. We want to understand and highlight and stop red flag behaviors before they turn into an incident of abuse. And so this might be that we observe a staff member who is spending a little bit of extra time with one student versus others. Maybe they're violating a gift giving policy, or they're finding ways to be alone with a child. And so those are red flag behaviors that if we teach our staff and our volunteers to understand that those are red flags and that they need to be reported, we can stop that behavior. We can intervene as an organization before that relationship escalates to an incident of sexual abuse. Everyone reporting their concerns. We talked about barriers to reporting. We want to, as organizations, create and have multiple different avenues for reporting concerns, but also that we, as an organization leadership, we want to, of course, respond to all of those reports that come in. We have employees that are engaged and they are actively implementing our policies, and we know that quality is institutionalized. So that is all of those things together, just a few simple things, work together to create this culture of safety and safe environment. Okay, so the last thing I wanted to share is another research project that our team has been working on, which is we did a benchmarking analysis of some national youth serving organizations, BGCA being one of them, YUSA, Big Brothers Big Sisters, Boy Scouts. I know I'm forgetting a couple, but we did this analysis to see, what are these organizations requiring? What are they doing? Because these organizations set the standard for the industry. And so looking at our safety equation, we did an analysis to see, what are they requiring? What are they doing? And so it was really interesting to see that these different breakdowns in the different things that organizations are doing within each of these different operations. And so we have a lot more detailed information about this analysis. If anybody's interested in seeing that, please reach out to me and we can chat more about that. But it's interesting to see this compared to the loss data analysis, because what we know with abuse cases, and many of you have probably experienced this or know about this as well, is that when an organization is facing an abuse case, they are really being compared to other organizations that are similar to them. And so if we have organizations, these large national youth serving organizations are setting the standard for what is required in the industry. And so if we have not as many organizations that are implementing certain policies, and we know that that's not an industry standard, then that may impact potential litigation that may face. So just really interesting to see a benchmark of how are these organizations really setting industry standard. Okay, so we also did an insurance benchmarking survey. And so what we found was that, and I mentioned this a little bit earlier, is that the insurance industry is becoming, it's hardening. And so it's harder and harder for organizations to get sexual molestation liability coverage. Or if they're able to get it, the limits are very low. And so as you can see from the large loss analysis, it's very easy to blow through a $1 million or $5 million limit for SML coverage. And so we did a survey with 13 different insurance carriers that work with youth serving organizations to insure them. And we really just wanted to understand what is happening in the industry right now. What are the market projections? What are the expectations that an insurance carrier has when they are potentially underwriting a policy for an organization? Do they expect to see policies, screening, training? What kind of benchmarks are they looking for? And then of course we wanted to see what are the different loss control services that carriers are implementing to be able to write more coverage, to be able to do that, but also provide some added value and really help with that risk management component. So out of that survey, 92% of them said that they expect that the market will continue to harden. 77% report decreased limits. So again, we're seeing a big decline in the amount that carriers are willing to write, and a lot of it is because of those large losses. It's very very damaging, and so it's understandable that an insurance carrier might feel hesitant to write a larger policy with a larger limit. 69% report lower coverage, and then 84% report increased premiums. And so we've seen from our clients that their biggest expense, oftentimes other than payroll, is their insurance premiums. And so it is very expensive. And so not only are premiums going up, but the limits are going down. And so it's becoming very difficult to have an organization that just really relies on insurance. And so we have organizations that say, you know, we know that if our employee gets into a car accident, we know we have insurance, but and so there may be less of a sense of urgency to focus on that risk management. But when it comes to sexual abuse, it's becoming more and more important that organizations really focus on those risk management things that they can do. So actual prevention versus just relying on the fact that they have insurance that will help them and cover them if they have an incident. So this part was I thought one of the really interesting parts of this, which was seeing what the underwriting requirements are. And so what are insurance providers requiring if they're going to actually issue a policy for an organization? And so 100% of them require written policies. Now, some of them require certain policies. Some of them just require that you have policies. They don't really look or verify what is in those policies, but requiring that there have to be written policies that guide conduct between adults and youth. And then defined screening requirements, 89%. And so it is kind of a mix between just requiring background checks and then also requiring more enhanced screening measures like interviews and reference checks on top of that. 89% require some type of training. That's where we're really seeing the least prescriptive guidance there. And that's where if we are partnering with a carrier to work with a client, we will really guide them on what is that training, what does that need to be, what does it need to include, again, using our standards from the safety equation to help them really get the most effective training, because we know that policies aren't really worth much if we're not training people on how to use them and understand them and implement them. And then, of course, the supervision of high-risk situations, that's a little bit lower at 67%. And I think that's just because of just the variance of the types of programs that different organizations offer. And so it'll be interesting to see if when we do this survey in a couple of years, if that changes. But having supervision requirements in place is very important, but that's going to look a lot different depending on the different types of organizations. And then, of course, having responding requirements, 89%. So again, that's one that's not as prescriptive from the carriers to say, we require you to respond in XYZ way. It's just the fact that we have some sort of responding procedure in place. And then 78% believe that these requirements will increase in the next 3 years. So again, we plan to continue to do this survey. So it'll be interesting to see how these requirements shift and change, and if they become more prescriptive, if they become less prescriptive. I can't imagine that will happen. But these are important for organizations to understand and know and be prepared for if and when they're seeking renewal for insurance or insurance for the first time. Just a couple more things before we wrap up. 71% of carriers said that they would be more likely to insure an organization who is accredited by some sort of external body. And so we know that there are different types of accreditations depending on the industry. We have American Camp Association, we have the Council on Accreditation, we have other social service bodies that work with like foster care and residential treatment centers. We have their school accreditations. And so there's a lot of different things out there. And so if there's some sort of external validation and support, someone saying this organization is performing at XYZ level, that could have an influence and an impact on their ability to obtain insurance coverage and potentially a higher limit or a lower premium. And so that's the 85% and 43%. So it's likely that they're still going to charge them the same amount of money or more money for that premium, but that limit might go up based on, again, not only the preventative measures that the organization is taking, but having that seal of approval from an outside external body. We're seeing the industry kind of moving in that direction where that's going to be more and more sought after and more might become the norm. Is any organization needs to have some sort of external accreditation or validation from another body to say, here's your stamp of approval, you're doing a great job. Okay, so that is the end. I think I'm a little bit short, so I know that we need to have time, so I can expand on anything, or I can take some questions if anybody has any questions. If not, okay, it looks like we've got a question. Okay, can you share what level, scope of background check you recommend for nonprofit? Yes, absolutely, and the average cost. Great question. So for nonprofits, youth serving organizations who serve youth, we recommend screening. Go back to that page. So we recommend screening based on their level of access to consumers. And so we define that out between someone who has high access to consumers and someone who has low access. So someone with high access is, we take it a further step there to help define that group. We look at duration. So how long will this individual be serving in this youth serving organization? And so, for example, is this someone who is only going to be here for a work study program for 9 months? Is this someone who is planning to be here only for the summer as a camp counselor? Or is this someone who might be here for an extended amount of time, just depending on where their career takes them? So duration, frequency, how often will this person be engaging with consumers? So again, is this someone who is going to be seeing consumers, maybe once a month, or is this someone who's going to be a frontline staff who is going to be around our consumers all the time? The type of relationship. So when we're determining access, we want to look at what is this staff or volunteer's relationship to consumers. So is this someone who is assisting in the front office of an organization, of a nonprofit, someone who may not have, any kind of relationship with the consumers that you serve? You may see them, you may interact with them a little bit, but there's not really a type of relationship there. Or is this someone who is like a mentor, who is intentionally and for purposes of the mission of the organization, developing a relationship with this consumer, an appropriate relationship? And so those are kind of the two ends of the spectrum. And then in between that, we have people like teachers, camp counselors, sports coaches. And so things where it is fully expected and normal as part of their role that they would be having a relationship, a positive, appropriate relationship with the child, but that they, the level of screening that those individuals get needs to be a little bit higher than, for example, someone who's just working as an administrative officer in a front office. And then we have privacy. So how much privacy will this individual have with youth, or how many opportunities for privacy? And so again, it's a spectrum. When you think of, if you're working with a client or directly in a nonprofit organization, you think of the different staff and volunteers that you have. There's a range of different roles and responsibilities that they have, and so they may have a longer duration and maybe a higher frequency that they're interacting with youth, but they may have the type of relationship and opportunities for privacy are very low. And so then they may not be deemed as high access. And so we use those for duration, frequency, type of relationship, and privacy, opportunities for privacy. to talk through that with organizations to help them determine, is this someone who is high access or is this someone who is low access? And so from there, this is a very long-winded way of saying, for high access volunteers and staff, and in any kind of organization that serves youth or vulnerable adults, we recommend a multi-state, name-based background check. We recommend a national sex offender registry search. We recommend a alias trace or social security number trace search. And then the most important thing that we recommend is a county level background check that checks all of the places that person has lived or worked for the past 7 years. And so we know that, and many of you know, that the most accurate and reliable criminal records live at the county level. And if we're only doing that multi-state check, or sometimes it's referred to as a national criminal check, if we're only doing that, we may not capture some of the results that live at the county level that may not be reported up, because every state, every county, everywhere has a different frequency with which they report up information. In Texas, we have 254 counties, and some of them report information in real time. Some of them it takes 2 months to get information into that multi-state database. So very important that we are implementing that county level check. And I know, like Boys and Girls Clubs of America, they made that a membership requirement, I think 4 or 5 years ago now, that any club who is hiring a staff member who is going to work with youth has to have that county level check, because again, that's the most accurate. And so that's for high access. For low access, and so these are individuals a lot of times that end up being volunteers who maybe they're working a 5K on the weekend. Maybe they're working in some sort of fundraising or donor capacity. They're working in an administrative office that they don't really see or interact with youth that they serve. And so these individuals, we still recommend that they have a multi-state criminal background check. And at the very least that they're being checked against the National Sex Offender Registry search. So, and that check is free. Anybody can go on and look at the NSOR. So that's something that a lot of organizations, particularly smaller ones, that that's really all that they're able to do from a resource standpoint is check those low access individuals through the National Sex Offender Registry. And so that's still obviously better than not doing anything at all. So so that's a very, very long-winded way of answering the background check question. Anything else? I think we have 3 minutes left. Okay, well, I am so thankful that I was able to chat with all of you today. I hope that I know this was probably a little bit outside the box of what you all do on a daily basis, but I hope that you learned something new, and please let me know. I'll go back to my contact information here. Please feel free at any time, reach out if you have questions or just want to learn more, or something didn't make sense, or you want clarity on something. Oh, I don't even have my email on there. How did I miss that? Let me pop it into the chat here. Yeah, so feel free to reach out if you ever have any questions or want to talk through anything else. Otherwise, I really appreciate the opportunity, and I hope that you all have a wonderful rest of your week.
Thank you so much, Audrey. That was really informative. I learned a lot, and it's so important too. So thank you for taking the time. So
Absolutely. Thank you.
This concludes our CLE session for today. And as a reminder, you do not need to do anything as far as CLE reporting. The bar will take care of that. And we have one session left in this series next Thursday, same time, same place. But that time the topic will be the basics of higher education law presented by Dr. Peter Lake, and that will run for 2 hours. So I hope to see everyone next week. Thank you.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.